Now let's bring in Mark Rifkin. He's a partner at Wolf Haldenstein. Mark, thanks so much for coming back in today. You've been helping us through this as we've been going through at first the trial phase and now waiting for a verdict. You just heard some of that wiretap that John Ehrlichman played. Was that the death knell in this case?
There's no question that the wiretap evidence was what convicted Raj Rajaratnam. It's mostly what the jury listened to, and it's virtually all that they asked for when they were deliberating.
The U.S. Attorney here in Manhattan, Preet Bharara, he released a press statement, and it reads in part, quoting here, Raj Rajaratnam, once a high-flying billionaire and hedge fund manager, is now a convicted felon 14 times over. Rajaratnam was among the best and the brightest, yet like so many others recently, Mr. Bharara goes on to say, he let greed and corruption cause his undoing. This is back to the future again. We saw this 25 years ago. I think we touched upon this the last time you were here. Don't people learn their lesson?
Until we change human nature, people won't learn their lesson. And having $1 billion isn't enough to say, I don't need to be tempted again. We learn all the time from rich people who do foolish things that human nature is a very, very powerful force.
Let me ask you something, because I'm going to ask some of the rest of our guests this today, but I want to get it from you first.
Sure.
Rajaratnam's lawyers were insistent that some of the information he got was already in the public domain, news reports, access to stock trends and such. And I realize, please forgive me if the question sounds too pedestrian, but what is the difference between insider trading and regular research, which is in the public domain?
Well, you have to keep in mind that there's a fundamental difference between speculation or rumor or analysts' opinions that are expressed all the time in the public domain. And that's the kind of evidence that the defense presented to the jury. There's a big difference between that and hearing the kinds of information that Rajaratnam was paying hundreds of thousands of dollars for or millions of dollars for, literally information that was coming right from the boardrooms, information that was not just idle speculation, not just opinion, but was cold, hard fact. It was so valuable to him, he was willing to pay enormous amounts for it. And I think what took the jury so long is they had to compare the information that he paid for that they heard on those tapes with the wealth of information that the defendants tried to convince them was what was motivating the trades. But there's just a fundamental difference between the two kinds of information.
In the wake of the Bernard Madoff trial, there were a lot of people who said, you know what, that the prosecution should not get so sure of itself, because juries being what they are, you talked about human nature, you never know. Right. How important was it for federal prosecutors to get a conviction in this case?
This was a landmark case for the prosecution. As you know, this was not the first of these insider trading cases to be investigated. This investigation has been going on. It certainly won't be the last. In fact, there's a trial scheduled to begin on Monday. But I think since this was the first one, and since Rajaratnam was such a high-profile defendant and such a wealthy defendant, so well-heeled, it was incredibly important for the prosecution to put their best case forward, and I think they did in spades here.
How does this trial turn out, perhaps without the wiretaps?
Would have been a completely different trial.
Really?
Absolutely. Absolutely.
How so?
The evidence of actually letting the jury hear the exchange of information from insiders. When Gupta calls and he says, look, here's what I heard at the board meeting. And, you know, moments after the board meeting is over, and then a moment or two after that, Rajaratnam turns around and makes a trade.
You can't unring that bell, can you?
You can't unring that bell. And really what the defense did was try to confuse the jury and distract the jury from the sound of that bell ringing in the air. And the jury took its time and heard the bell and did what they did.
What's the appeals process look like?
The issue on the appeal, the fundamental issue on the appeal, is whether the court should have allowed those wiretaps in as evidence at all. Certainly, with respect to tapes that did not include Rajaratnam, their argument is that it's all hearsay and it should be excluded. That's a legal argument that the judge has already considered and rejected, and now the defense wants to present that to the Court of Appeals, to the Second Circuit. That was the comment that Dowd made.
Mark Rifkin joining us on set. It's a pleasure to have you. Thanks for staying with us through this. Thank you so much.
Sure.